This voice thread will be an introduction and brief overview of the Fifth Amendment. So the Fifth Amendment deals with a number of different and largely perhaps unrelated rights. So today we're going to focus on a few of them in a bit more detail, and then when we resume next time, we will get into more detail with some of the landmark cases. Here we have the text of the Fifth Amendment, and this outlines a number of different cases. So I'm going to point to a few of them that we're going to discuss in more detail than others. So in this class, we're not going to spend a lot of time talking about grand juries or indictments. However, we are going to look at the things that we see as being perhaps more central to our civil liberties, right? Or the rights and freedoms that we enjoy as citizens of the United States. So the first of these that we're going to look at is what's referred to as the Double Jeopardy Clause. So the text that you can see here in the Fifth Amendment says, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." So you've probably heard of the Double Jeopardy Clause referenced before. And what this means essentially is that a person cannot be tried criminally for the same crime more than once, right? So if there's an acquittal the first time, that's the end. Even if they are convicted and maybe don't get a sentence that the state is happy with, the state can't bring them back, try them again, and try to get a heavier sentence. So does this mean that once a person has been tried, they kind of go scot-free? No, not necessarily, right? And so we'll discuss this in a bit more detail as we get into some of the cases. But we've discussed in this class before the idea of charge stacking, right? So prosecutors can stack charges related to the same incident so that you have more than one charge, right? So perhaps the first charge is armed robbery. There's a related charge of perhaps false imprisonment if there was, some part of the incident in which a victim was held against their will. There may be other things, having to do with possession of the weapon, or various other types of related offenses. The point being that one event can involve a bunch of different legal charges. And so in that case, you're being tried for multiple charges, not for one. And so even if you are acquitted on one, you might be convicted of another. This also doesn't affect the bringing of a civil case. So a person who is acquitted on a criminal charge might still be subject to a civil lawsuit related to the same event. And in that case, the threshold of evidence is lower. So even a person who's been acquitted of a criminal offense may still be held in some way liable or at fault for having been involved in that event in a civil case. All right, so this brings us to the next part. So, nor shall be compelled in any criminal case to be a witness against himself. So this is the famous part of the Fifth Amendment where you'll see people on TV and movies talk about taking the fifth. What does taking the fifth mean? Well, exactly this, that in a criminal case, and specifically a criminal case, no person can be compelled to be a witness against himself, right? So what does that mean? Well, we'll discuss that also in a bit more detail. One way to phrase this is that you cannot be forced to give testimony against yourself, or you cannot be forced to incriminate yourself. All right, so finally, this brings us next to the Due Process Clause. You're probably at least somewhat familiar with the Due Process Clause because it's referenced quite often in various contexts. But this reads that a person is not to be deprived of life, liberty, or property without due process of law. So this doesn't mean that you can't be, under any circumstances, deprived by the state of your life, liberty, or property, obviously, right? Because there are states that put people to death for criminal offenses. We have imprisonment, that's a loss of liberty. And we do see people's property taken, right? So we will discuss later in this unit later in this class, when we get to the Eighth Amendment, we'll discuss civil asset forfeiture, right, which is a case in which people's property is taken, arguably without due process of law. But we also see people being held liable for fines, right? So you may be fined by the state for committing certain kinds of offenses, and that is a deprivation of your property, right, in terms of money. But for the state to be able to do this, it has to go through certain steps. And the argument for this being that there has to be some kind of fairness. So in constitutional law, we will often talk about different kinds of fairness. And so we might talk about procedural fairness or substantial fairness. So the difference between these two things is a matter of what and a matter of how. So substantive questions are sort of limits on what the state can do, period. Procedural questions are questions about how the state can go about doing something, right, that we've already agreed the state can do. So due process of law, the obvious example of this is a criminal trial, right? There are certain procedures that have to be followed. If those procedures are not followed, then whatever coercive penalty comes after the trial cannot be imposed. So we will discuss due process in our exploration of the Fifth Amendment. And then relatedly, we will discuss also what's called the takings clause, which is this final part of the Fifth Amendment, which reads, nor shall any person be deprived of their nor shall private property be taken for public use without just compensation. So this has to do with what is referred to as eminent domain. Eminent domain is one of the powers of the state, which is to say the state, in some circumstances, reserves the power to take private property for public use. If it is assessed to be sufficiently in the public interest to take possession of a person's private property, then the state does have the power to do this. It's not an unlimited power, right? And this can be done without the consent of the property owner, obviously. There are limits on the circumstances under which this can happen. And there's also the requirement that there's just compensation. So before we get into those cases, I do want to raise a question for you to think about, which is whether or not compensation is a sufficient mitigating factor in the injustice of taking someone's private property, right? So obviously, it's unjust to take a person's private property and simply not compensate them. We call this theft. No matter who is doing it. But is compensation enough, right? So is paying for something, even though you are violating the property rights of the owner by not getting their permission to take it, does that do enough to justify the taking? So one example that I will give is perhaps the taking of a house, right? So houses have all sorts of value. Obviously, they have their monetary value or their market value. But if a house has maybe been in your family for many generations, or even if it hasn't been in the family for generations, but the person who's lived there has been there for many years, has a sentimental attachment to the house, can any amount of money actually compensate for that? And isn't it basically still a violation of the owner's autonomy to take their property without their consent, even if they're being paid for it? Obviously, what the Fifth Amendment says is that the compensation is sufficient. But I want to raise this as like a political or normative question, whether or not we actually think that this is justified. So as I mentioned in the last slide, this is kind of an assortment of rights. So as you'll see in your reading, there are a number of different lines of cases dealing with each of these. So I'm just going to touch on a couple of them now in a sort of introductory way. But the first one I want to point to is the Blockberger test, which deals with the double jeopardy clause. So this is a case from 1932 in which the court held that the same evidence can be used to try a defendant for more than one crime, but only within the same trial. So this case deals with the question of what is actually the same crime, right? And so can a person be charged with one offense, tried on a certain body of evidence, maybe found not to be guilty in that case, but then brought back to court on a different charge using the same evidence? And so the court looked at an instance of this and said that this is, at least in spirit, if not maybe in, by the letter, being tried more than once for the same crime in violation of the double jeopardy clause. So I would like to just return to takings in more detail after the break. But I do want to draw your attention to the most prominent of the eminent domain cases. You've probably heard of this one. That's Kelo versus New London. So this was a case in which a person was compelled to give up their home, right, for the economic development. But the economic development in this case, it wasn't simply that the town wanted to undertake a public works project, but this was actually development by a private entity. So the argument was that even though the development was being undertaken directly by a private entity, it had enough of a public benefit down the road in terms of providing economic opportunity that it justified the taking. So take a look at Kelo versus New London, reflect on it, maybe formulate your thoughts as to whether or not you think in that case any amount of compensation was sufficient. And also, consider whether or not you think that the involvement of a private entity significantly changes the calculus in this case. Okay, and then finally, as I mentioned also in the last slide, we are going to look at the difference between substantive versus procedural due process. So sometimes legal academics will criticize the term substantive due process as being sort of nonsensical, right? Process is by definition procedural. That's what procedural means. But there are distinctions made in these cases. Again, that distinction comes down to, in the terms of what's substantive, like what can be done, like what is the limit on what the state can do, versus procedural issues, which are dealing with what steps need to be taken to justify undertaking one of these ends. All right, so after today's discussion, I will post another voice thread that goes into a bit more detail regarding specific cases connected to the Fifth Amendment. And those slides follow after this, but this will be the last slide with lecture on it. And what I want to raise before we get into specific cases is this question of what self-incrimination actually means, right? So as I mentioned in the introductory slide, perhaps the most sort of publicly familiar face of the Fifth Amendment is quote unquote taking the fifth, right? Which is invoking your right to not incriminate yourself. But what does it mean to actually incriminate yourself? So we're going to discuss some overlap between the Fourth and Fifth Amendments in regard to the Louis Philippe story that I raised last time in class. But what does it mean to actually incriminate yourself? So can you be forced to incriminate yourself by being forced to unlock your phone with maybe your face or your fingerprint without your consent? Is that a search and seizure problem? Or is this more a matter of you being forced to be complicit in gathering evidence against yourself? So the root of the right to not incriminate yourself is essentially that you can't be compelled by the state to act against your own self-interest, right? So this is framed as essentially being a violation of your dignity and autonomy as an individual. You should always be able to, so if you want to put this in terms that Thomas Hobbes might support, you always have this right to protect yourself in this basic way, even from the state. And so you can't be compelled to testify against yourself, to give evidence against yourself, etc. So what the court has come to in terms of what this means, and this is a bit of a wrinkle in the current court decisions regarding biometrics, is that self-incrimination hinges on the use of what's considered testimonial evidence. So there are two key elements to self-incrimination. The first is that that there is some sort of compulsion in getting what's, again, termed testimonial evidence that incriminates the person who is being compelled to provide it. Right. And so second, that evidence has to be compelled by the government, right? So a private entity forcing you to release evidence against yourself, right, under whatever circumstances, isn't a constitutional issue. It's not a Fifth Amendment issue. But if the government is in some way compelling you to give, and I quote, testimonial evidence against yourself, that is a violation of your Fifth Amendment rights. But this raises the question, what is testimonial communication? right? So the idea of self-incrimination arose initially with an eye to interrogations or specifically trials, right? So being sworn, appearing in public under oath, and then being compelled to give evidence verbally against oneself. But obviously, it's 2020. There are all sorts of other ways that we relay information about ourselves, either, as we discussed with the Fourth Amendment, often unknowingly or knowingly. But so the question that arises now, with many of these cases involving biometrics and access to data, is what qualifies as testimonial communication? Traditionally, we see testimonial communication as being verbal, so some sort of statement. Should we consider fingerprints to be a violation of your right to resist self-incrimination? What about using facial recognition? Is that a violation of your Fifth Amendment right? Because essentially it's using your body to convey information that then is used to convict you of a crime. So it has that same basic logic of being compelled to betray yourself. That is underlying the Fifth Amendment's self-incrimination clause as a whole, but it is also missing that verbal piece. So what do you think about this? Should we only consider testimonial evidence to be words that are spoken, written, etc.? Or should we also look at, should we define maybe communication a bit more broadly to include things like the use of your face or the use of your fingerprints without your permission? All right, so that's all I'm going to raise for now. We will discuss this as a group via Zoom. And I will talk to all of you soon.